So there's a lot of case law that shows that if any law is repugnant to the Constitution, if it violates the Constitution, if it's in conflict with the Constitution, then it's null and void and it can be ignored. You can look at the Marbury versus Madison 1803 case with Chief Justice John J. Marshall. And there's other cases as well. And there's California Public Law 37100. If any law or code or mandate or whatever is in conflict with the Constitution, then it can be ignored. It has no force or weight of law. It's null and void, basically. But here's the main thing. It's hard to rely on the Constitution for everything, because the Constitution, as in my understanding of it, was really more of a contract, sort of a trust between public servants and the people, and so it's basically the public servants are bound by that. That's why they swear an oath to uphold and defend the Constitution. So it's their thing. It doesn't apply to the people. What applies to the people is common law. Common law is not written because it's written into your heart. Common law is derived from natural law, which is don't violate the property rights of other sentient beings. Honor your contracts, And what happened is, in 1933, this is where we got off the common law and the Constitution, being able to really rely on that. And we filed bankruptcy every 70 years. The bankruptcy renews. And we essentially switched from going from common law to what it was. And between 33 and 37, this was this transition period where we got more into contract law and commercial law. And so now everything is commerce. And that's why the UCC, Uniform Commercial Code, is this uniform, universal commercial law system. And that is really what governs us now, is commercial law and contract law. So yes, we have a Constitution. And yes, if any law violates the Constitution, we can ignore it. However, the main system of law that we're in now is contract and commercial law, and really admiralty, maritime law of the sea. So admiralty being military and maritime being a law of the sea. So it's really confusing, but you can't really just say, hey, we have constitutional rights and I'm going to ignore this because it violates that. You can say that, but that is more of a contract between the government and the people, saying, if you step out of line, we're going to put you back in your box. Okay, public servants. Okay, it's something for the public servants. It doesn't. We don't swear an oath on the Constitution or on the Bible or anything like that. They do. They swear an oath on the Bible to uphold and defend the Constitution. So just take away from this that if you want to play their game, you will play the commercial law, commerce law, contract law, and really understand the concepts behind that. And there are 10 maxims of commercial law. Just familiarize yourself with those, absorb those, because in this game, everything is contract offers and how you react to those. Okay, they're just throwing contract offers to us. If you look at these orders and mandates and guidelines, and what the real definition of a mandate is it requires consent, essentially. It requires agreement by the mandatary, the one being mandated to. So if the mandatary does not consent or agree to what's being mandated, then it's a null and void mandate. And it's also, if it's unconstitutional and violates your religious creed or your privacy or your ability to bear arms, then it's null and void. Okay, but you want to operate in the form of commercial law and how you accept those contract offers. For it to be honorable, you want to be the honorable creditor, okay? So rather than focusing on constitutional law, focus on commercial law and contract law. And when an offer gets sent your way, you want to look at the honorable ways to accept these so you're not in dishonor, okay? Because then when you're in dishonor, that makes them the creditor and you're the debtor. And a debtor, according to the Bible, is a sinner. So you don't want to be the debtor. You want to be the creditor in all affairs, if you can, right? And so you have to learn how to accept a contract offer. So it's really simple. You accept a contract offer by agreeing to it, okay? You give your consent, basically, okay? And you do what they say in the contract offer, okay? The dishonorable way of accepting a contract offer would be silence. So silence is seen as agreement through assent rather than consent. So when you assent to something, you're not speaking up. When you don't speak up, you are essentially agreeing to it. Again, if you do not speak up when a contract offer is thrown your way, you are agreeing to that contract offer, okay? A dishonorable way would be arguing, okay? So arguing and silence are not things you want to do with these contract offers. What you want to do and what we want to do is use our paperwork, our affidavits, to form new contracts. And when an offer comes our way, we can accept it conditionally. This is the last form of a way to accept a contract offer, is conditional acceptance. So you conditionally accept it upon proof of claim. So if they are saying you have to do something, you say, I accept that and I will do that as long as you can show me the law that says you can do that, and under what authority says you can do that, and what authority that law has over a man or a woman rather than a person. So if you focus on these and really absorb these concepts rather than the Constitution says we can do this and that. Remember, the Constitution binds the public officials. It's nothing to do with you and I, really, okay? It's just when they get out of line, okay? But what we're in now, again, is commerce and contracts. Acceptable ways to accept contracts offers is acceptance, just agreement right away, or conditionally accepting upon proof of claim. And the things we don't want to do is go silent and argue, okay? If we can learn these concepts and apply them with our paperworks, learning the private process, how to write affidavits, and how to conditionally accept contract offers, we will all be a lot better off. And instead of feeling hopeless with all this lawlessness going on, you're going to feel empowered. And you can then utilize these concepts with your paperwork and let your paperwork speak for you. Create a new contract, and then you're going to have something that can be enforced in court. When you have a contract, all the courts are is basically just there. If someone breaches contract, breaches the trust, the courts can come in and say, yeah, you guys had a contract, you breached that, you owe this plaintiff damages or injunctive relief, something like that, right? So focus on commercial and contract law, but also just understand that constitutional law, it does apply to those public servants, and we can use it, and we can stand on the Constitution, you know, our right to privacy and be secure in our papers and effects, and right to bear arms, freedom of religion, freedom of speech. We can rely on those, but in this system since 33 and 39, that area, when we did the last bankruptcy before 9/11 bankruptcy, we switched from common law to commercial and contract. So hopefully that makes sense, and study contract commercial law. You'll be more empowered, learn how to write affidavits, you'll be able to control the contract.